Good morning, everyone, and thank you very much for participating this morning. For those of you who don't know me, my name is George Kounis. I'm a member of the Click Law Partners team, a non-solicitor consultant dealing with Cyprus property matters. As you would be aware, the subject of today's seminar is the closure checklist, basically to go through your Cyprus property matter and see how to reach closure. I'm going to go through various slides and comment on them. But as we go through the slides, please remember that the information which is being provided is generic. In other words, it generally applies as opposed to specifically applies to your case. Before you can use any of this information, you should really provide details of your case and the specific information, specific advice needs to be provided on your own individual case before you can rely on it. I trust that this is quite obvious. The presentation is split into three parts: what needs to be closed, what other things need to be closed which you may not be aware of, and also the last part is basically to answer the eternal question: is, if these people are at fault, why do I need to pay for it? The last part of the presentation is a quick question and answer session, and I will start going through each of the sections in turn. So what needs to be closed? The characteristics of your Cyprus property matter are that it is mainly about the fall in prices, anticipated income, and overcharging. There have been other breaches as well, but in terms of the problem that you're facing, most people are faced with a property which they purchased, and the value of it today, maybe 15 years later, is half of that of what they purchased it for. They purchased it anticipating rental income, which never materialized, and they also purchased it using a loan, which, for one reason or another, maybe because it was in foreign currencies, in a foreign currency, or because of overcharging interest, it swelled beyond belief. So most of you are facing a negative equity. Some of you have paid substantial amounts towards the loan, so you may be in positive equity. That's fairly rare. But again, you may be in overall negative equity when you add the repayments you've made and the deposits that you put in. Now, by negotiation, full restitution is impossible. One is told never to use the word impossible, but in logical and pragmatic terms, you're not going to get everything you may get if you go to court and you win hands down. But then again, there is a problem in calculating that you're going to go to court and win everything hands down. Your opponents also have arguments, and if you then look at where the negotiation has taken you and look at the marginal benefit of what you might win, then the case for adjudication, for litigation, and the risks involved with that diminishes substantially. So this is why you will find that most law firms today are talking about negotiation as opposed to litigation. So this is where we stand. One of the main problems in reaching closure for us and for you is managing expectations. Now, there are people who are quite pragmatic, quite realistic, and they say, I got into a problem 15 years ago, and I'll be glad to get out of it. Other people are saying, I went to Cyprus, I was strict, it's all their fault, I was the innocent bystander, and I want everything back. In fact, we've had some clients even asking for a lot more back than what their actual losses. Now, we can deal and we can bring about a very realistic settlement for people who are realistic. We cannot represent people who are not realistic in terms of the prospects of reaching a negotiating settlement, are not realistic in terms of the prospects of succeeding in litigation, and also people who somehow not willing to pay. They think that this service should be provided for free, which may be a strong argument, but it's a strong argument to put to a government, not to a firm of solicitors. We are obviously trying our best, which I will explain during this presentation, but not to the extent that each and every one of us needs to do it as a charitable contribution. We cannot sustain it. If anything, because to run a firm of solicitors, there are expenses. We need to be insured, we need to be regulated, we need all of these things. So whether we like it or not, this expenditure has to be incurred, even if we were doing it for free. But again, we will go through this, but it's very important to know exactly what we're talking about and not to expect miracles. You can expect a very reasonable, a very realistic settlement, and if you bear with us, to reach closure in due course. So what is possible by negotiation with the bank? So let's start with the bank, and the reason why we're starting with the bank is because this is where the main threat and the money is. They often say follow the money. The solution to your problem, or shall I say the 90% of the solution to your problem, is settling with the bank. So what is possible as far as the bank is concerned? We say that the elimination or the reduction of your negative equity, if you're getting rid of the property, is possible. And when we're talking about the negative equity, we're talking about the value of the property taken away from the amount outstanding to the bank. It is, if you like, the net negative equity as opposed to the gross negative equity, which is when you then add any repayments you've made and deposits and other expenses you incurred. So the elimination of your negative equity, or the reduction of your negative equity, if you're getting rid of the property, is possible. If you're keeping the property, it is also possible that you may be left in positive equity, depending on the level of repayments you have already made. We can negotiate that for you. Is restructuring possible? The restructuring basically meaning that what you currently owe is reduced, and the repayments are recalculated from scratch so that you can repay it in installments. This is only possible with Alpha Bank. So if you want to keep the property and you're looking at restructuring, then Alpha Bank will do it. Bank of Cyprus, Hellenic, National Bank of Greece will not do it. They want these matters closed. So their attitude is, when we're talking about a settlement, we're talking about settling in full now, not at some future date. There are also certain caveats about restructuring, which I will refer to later. Again, do not assume. I'm adding the same condition as I said at the beginning of this presentation. You need to have specific information, or we need to provide you with specific advice on your specific details. And do not rely on generalizations, which are the only way to do such a presentation. So things will differ according to your circumstances. What is possible by negotiation with developers? Now, again, some people think, well, I can settle with the bank and then go after the developer, and the developer should cough up effectively the deposit paid to them. They should compensate me if they gave me a rental guarantee, or they gave me promises about rental income which were not realized, and so on and so forth. Well, I'm sorry to dampen your expectations. Developers will not refund deposits paid, and we believe we're going to have difficulty in certainly they will not do it by negotiation, and we think we're going to have difficulty with litigation when everything is taken into account. They also have arguments about the sales process. Their main argument would be caveat emptor, buyer beware. So we are here talking about the margin, one being that the purchaser needs to have carried out their due diligence before they're purchased. Otherwise, the seller cannot just say, well, I had to make sure that the purchaser understood. That is the onus is on the purchaser on the one hand. On the other hand, the seller should not mislead, should not misrepresent. So this is where the main arguments would come in. And then we have something else to deal with, which is who gave this information. And in most cases, the answer is sales agents. Now, a lot of these properties were sold through networking, whereby somebody did buy a property from the developer, and then that somebody was told, well, if you introduce clients to us, you can get a commission. So a lot of these sales agents ended up being sales agents by networking with their friends. And some of you may have bought with someone who is a friend, or for that matter, used to be a friend. The developers would argue that they were not their agents. Their argument is that under Cypriot law, an agent is only someone who is an officer of the company or has a power of attorney. Somebody who simply introduces somebody, an introducer who gets commission, is not my official agent, and therefore I bear no responsibility for that. Again, there are counter arguments for that, but you can see how things would go in court. They also have an argument that your Cyprus lawyer should have done a lot of the due diligence when you purchase the property. Now you'll say, but you introduced me to the Cyprus lawyer. Yeah, I introduced you to someone. You were free to go to wherever you wanted to, but whoever I introduced you to is still a lawyer bound by the rules of the Cyprus Bar Association, and they should have protected you. So why are you coming to me? So you can see again where this argument is going. And the other main argument that would worry us the most is that if you're settling with a bank, you're using the whole of the property to settle. What do I mean by that? Is that let us argue that when you purchase the property, you funded it to the extent of 20% by paying a deposit of 20% or 30% or whatever, and the bank funded it for the remaining amount. But when you're settling with the bank, you're giving the whole property back to them. So you have used the whole value of the property to reach a settlement with the bank, and the developer would quite rightly argue that if they give you your deposit back, effectively, they would be compensating you for something that they had to give away to settle your loan with the bank. So again, you can see that the quantum, the amount of your losses, which is at the end of the day the most important thing. When you go to court, a lot of people say, they are at fault, they acted wrongly. This is all to do with liability. Where most cases disappoint, most court judgments disappoint, is on the quantum, on the award that is then being given, because the judge then sits down and says, yeah, okay, they were at fault. However, right, you've got to take this into account, that into account, in order to arrive at the quantum. And here again, you would see that taking the risk of taking a developer to court for a certain marginal benefit may not be worth it. Now, we're not giving specific advice on this. We're giving you an overview, and a lot of times having an overview saves you from a lot of expensive specialist advice that will more often than not result in pretty much the same conclusion. What we can do with developers is to negotiate over unpaid stage payments. In other words, if you bought the property off plan and you had to make, let's say, 5 stage payments, you've only made 4 of them, and the 5th one, you told the bank, well, I'm not allowing you to give the 5th one because they did not finish it on time, or because there are defects, or whatever. When we're settling with the bank, we should be able to set that last payment off, set it off against the loan that the bank has given to the developer in most cases. So that can be done. The other thing that we can look at, although it's not included in our standard retainer, is also to negotiate over the running expenses. Now, what we mean by the running expenses is that from the moment you become an owner of the property, you become liable for property taxes, management, and maintenance expenses, insurance, and what have you. Most of these running expenses are paid by the developer because officially he's the registered owner. You are the beneficial owner under the sales contract. But you are still liable for them, even if the developer has paid for them. So the developer will say, you owe me money. You owe me 5,000–10,000 euros, made up of these maintenance charges, communal fees and what have you, made up of property taxes that I had to pay on your behalf, and so on and so forth. A lot of them will add substantial interest to that, and we can negotiate these running expenses as part of reaching a deal with the developers. So this is where we are. In terms of closure steps, the closure steps on paper, they look pretty straightforward. First of all, you need to decide whether you wish to keep the property or get rid of it. You can get rid of it either by surrendering it to the bank or by selling it and giving to the bank the proceeds. Once you have decided that, then you settle with the bank, depending on what you have agreed to do, what you have decided to do, and the next step is to settle with the other opponents. So the closure steps look quite simple to follow, but each one obviously involves quite a lot to take into account and quite a lot to do. What you must not do is to leave matters outstanding, because they can come back and bite you. A lot of people have buried their head in the sand. 15 years ago, when they bought the property, they stopped making repayments, and maybe they've been bothered, maybe they haven't been bothered because they've moved address and what have you, and their attitude is, well, yeah, I've been anything I get from debt collectors, I ignore them, I've moved address, they can't find me, etc., etc. Now, we would caution very strongly against having this attitude permanently, because for reasons I will explain, it can come back and bite you. You do need to address it if you do not want to suffer the consequences. What banks have been doing is what you would call go for the low-lying fruit, the less difficult cases. The more difficult cases, they're going to leave at the end. But of course, for them, they are simply going through a process. Banks are pretty faceless. They will simply either get employees to do the necessary, or they'll get they'll sell off the debts to other companies who will do the necessary. For you, having waiting for the next threatening letter or the writ or whatever to come through your letterbox for the past 15 years, and looking at that prospect for the next 5 or 10 years is not a good way to live your life. So we'll go through that in a minute. Let's go through the checklist for each, depending on what your decision is. If your decision is to get rid of the property, the closure checklist needs to look, or will look something like this. First question is the loan paid off? So, you've surrendered the property, or you've sold the property, you've given the proceeds, the bank has written off whatever they have agreed to write off. Is the loan now closed? And we put a tick mark on that if we want to progress to the next step, which is have the land registry transfers been affected? So do I have anything to do with the property as far as the land registry in Cyprus is concerned? Again, you need to put a tick mark on that before you can say that, well, that aspect is also closed. Have all legal actions been withdrawn? Maybe you have sued the bank, or they have sued you. You want these actions to be withdrawn. If you don't withdraw actions, the potential of legal costs or adverse costs is always there. So that also needs to be done. Have all bills been taken over? So the minute ownership passes either to the purchaser or to the bank, they also need to take over all bills, so that you're only liable up to the point where the transfer has taken place. If you get all 4 tick marks, then you know that you got rid of the property and the matter is closed. If you're keeping the property, you need to start from a very fundamental question. All we are doing is we are getting the bank to withdraw its charge on the property when the matter is settled. So let's say that the bank they say that they are owed 200,000. There's an agreement that you're going to pay them 100 or 150 or whatever to keep the property. They receive that money and they withdraw their charge. Now, once they withdraw their charge, they, or for that matter we, do not fix anything else that is wrong with your title to the property. So in the same way that you bought the property when you bought it off plan, the only thing that has happened is that whatever beneficial interest you had in that property was assigned to the bank, for which they gave you a loan. Now, you repay that loan by negotiation. You are then left with they would remove any charge, any interest they have in that property. You would still be left with a situation where, if there are no title deeds, that remains your problem. If planning has not been complied with, that remains your problem. If other charges have gone on the land because the developer owes money, that remains your problem. Neither the bank nor this firm can fix that. What you need to do before you even decide to keep the property, you need to instruct a separate lawyer. There are other people who can do it, but they're not insured. So if you want the reassurance that the work has been done properly, or you can claim if it has not, you need to instruct the Cypriot lawyer to produce a report on title, which is exactly what you're doing when you're purchasing a property in this country. When you instruct the solicitor, the first thing that they will do is they will do land registry searches, and they will give you a report on title, and they will say, okay, there's only a charge in favor of Halifax, which is the building society of the vendor. When you pay off, we will make sure that Halifax is repaid, and therefore you're left with a clear title. If there are instead of the one charge to Halifax, there are another 5 charges, your solicitor over here would advise you and say, well, they also have other charges on the property, or there are other problems in terms of planning or whatever. This is what the report on title. You need to do pretty much the same thing in Cyprus. So before you even decide to keep the property, you should have got a report on title, and you're satisfied that once a settlement is reached with the bank, then you're satisfied that what you will be left with is acceptable to you. A number of people have come back to me saying, yes, but I want to keep the property. What about title deeds? And I said, we have been saying for months on end, giving exactly this advice. Why have you not heeded to it? Well, I don't know what to do. Well, you've got to instruct the Cypriot lawyer. You cannot expect, when you're giving instructions to solicitors or to whoever, you're effectively asking them to do something fairly specific. Right? If you've got problems with your property, you're going to instruct a plumber to deal with the plumbing. You're going to instruct an electrician to deal with the electrics. You cannot just assume that the electrician will also deal with the plumbing. You know, that's obvious, and I trust that most people will realize this. So once you're satisfied that is what you will be left with, then a settlement is reached, and the loan is effectively paid off, unless you're restructuring, which is another matter. The loan is paid off, and then can say, okay, is the land registry encumbrances being removed? So my title is effectively free. Presumably there are no other encumbrances on the property, because very often, since the bank lent the money, maybe the developer owes money to the Inland Revenue. The Inland Revenue may have put a charge on the land, and that charge applies to all the properties that are built on that land. So this is what the report on title will tell you before you decide to proceed. So have all the encumbrances being removed, have all legal actions being withdrawn, and if restructuring loan, can you repay it? Now, this is where there is a problem with asking for restructuring, because Alpha Bank will restructure, but they're saying we do not want to trade one bad debt for another. So I'm not going to give you, I'm not going to write off, let's say 100,000 euros off your loan, only to find that you're not paying the remaining loan. What I will do is, let's say that there is the loan is the original loan outstanding is 200,000, and they have agreed to write off 100, leaving you with a loan of 100. They will create effectively 2 loans: loan A, 100, which you actually owe, and loan B, which is the amount that they're going to write off. And that will remain there so long as the loan A is outstanding. Only if loan A is repaid, then loan B will disappear. In actual fact, restructuring deals that we have done, in order for them to give you a competitive interest rate and to be enticed to do the deal, there's in addition to loan A and loan B, there is in actual fact another loan which is where they're getting a share of the increase of the value of the property over the next 10 years. I'm not going to go into that because it's a complicated arrangement which I negotiated with them. Doing it that way is obviously in the interest of the clients, but the main problem with it is if you cannot repay it, if you don't maintain the repayments. If you do that, then everything is going to go fine. But you need to anticipate what would happen if something goes wrong. And if something goes wrong, then you're stuck with it. So you need to make sure not only that you can afford the repayments, but that you have also catered if something has gone wrong. You're made redundant, ill health or whatever. Is there someone else who can step in? Is there another income, maybe a relative or children or parents or whatever that can step in and bail you out? If not, then don't do it. It's as simple as that. You don't want to land from one problem into another. Moving on, this is basically the basics on closure, but I will now move on to another chapter, which is what else needs to be closed, because there are what one might call stealth charges, stealth liabilities that most people do not consider, and they are there and they do need to be dealt with. So settling with the bank may be only the beginning. The next steps depend on what issues are outstanding. Outstanding matters may be categorized into opponents who are already in litigation with. So you may, for example, be in litigation with the developer. The developer may be suing you for normally outstanding installments or maintenance charges or whatever. And other opponents who are claiming money from you, but who have not sued you or served proceedings on you so far. So there is this slight distinction, although it all emanates from is there a liability to someone else in Cyprus that can come back and bite me? And normally you would have received some sort of a notification, even if you don't recognize them. Very often there are management companies that have been appointed. In a lot of cases, the maintenance management company for the development is the developer. So you know that you are dealing with the developer. Very often the developer has created a sister company and they say, well, it's got nothing to do with us, when in actual fact it does. Often it's gone to a completely third party company who are doing the maintenance, and sometimes it could even be an owners committee. Now, what is their standing, whether they are entitled to do this under the terms of the contract or whatever, is another issue. The main problem is that anybody can walk into a court and get a writ against you. And if it's a foreign writ, it's issued in Cyprus, and you do not oppose it, you can't find that it's enforceable in this country, and the enforcement of it is unstoppable. That's the main issue that I'm trying to highlight to you. So even if things have been coming through the letterbox and you've been ignoring them, saying, who the hell are these people, why don't they leave me alone? And I have been ignoring them and nothing has happened so far. Well, it may happen when you least expect it. So it needs to be addressed. And I will go through, I've created a table to take you through the various aspects that need to be addressed. So where you're talking about the developer, vendor, the development company that sold you the property, what you would expect is due to them would be normally the communal charges, or what called the property management costs, and property taxes. Again, because the property was in their name, they are the registered owners, and the government says, well, you need to pay the property taxes and claim it from the beneficial owners who are you. So they are running up a bill. They're expecting to be paid. Now, you may have sued them in this country, claiming your deposit or whatever, but they may have also sued you in Cyprus, or they can potentially sue you. So this needs to be taken into account, and this needs to be settled with them. Management companies, if they're separate from the developer, the property management costs they would be claiming, we have seen some pretty nasty management companies, or even owner committees who are pretty aggressive. They just go straight to court and get a judgment. And again, that should not be ignored. If you've got anything like this, any such notification, you do need to bring it to our attention so that we can deal with it, or you should deal with it yourself. Do not ignore. I can't repeat that strongly enough. Lawyers in Cyprus. Now, this would be normally, if you have been sued in Cyprus by the bank, somebody, a lawyer, would have gone on the court record. And once they go on the court record, they are entitled to be paid. Now, you might say, well, I did not appoint them. My solicitor in England appointed them. I've got nothing to do with them. I don't know how much they're charging. I don't care how much they're charging. But the fact of the matter is that under Cyprus law and under Cyprus practices, you may have a lawyer that you've never met, you've never instructed, who are on the court record. And all they need to do, they don't even need to sue you for the money. All they need to do is go to the registrar, the clerk of the court, if you like, who will carry out the administrative task of going through your itemized bill, open the file, the court file, and start going through and say, right, you're charging for an attendance on such and such a date. Did you attend? Yes. Are you charging in accordance with the scales approved by the Supreme Court in Cyprus? Yes, that charge is approved. The next one, either there was no attendance, or you're charging more than the approved scale of the Supreme Court. Therefore, you'll bring it down. But at the end of the day, you will end up with a bill which, let's say, was 6,000. Maybe the registrar will say, no, it's only 5,000 that is due. He will rubber stamp it, and that amounts to a judgment. It's not going to go anywhere else. It's a judgment which can then be registered in this country and enforced just like any other judgment. And it's unstoppable. You cannot go to the English court and argue the rights and wrongs of that bill or any judgment that has been issued in Cyprus, because that would be interfering with the judgment of another court. The most that the court here will give you is time to go and challenge it in Cyprus, which again means double the cost, because you will have the cost of asking for a stay in this country, plus the cost of going to challenge it. So it's best that you deal with it at source before it happens. Then the last grouping I have is Cyprus authorities. Normally, you'll find that in order to transfer a property, the land registry will require a tax clearance certificate. So somebody will have gone to the tax authorities and obtained a tax clearance certificate in your name before you can either sell the property or surrender the property to the bank. If you're keeping the property, it's again wise to check what is your tax status in Cyprus, how much you owe to the revenue. It may be that you can get a tax clearance certificate simply because the developer has paid for it. And this is again, there's nothing outstanding to the authorities, but the developer is claiming that money from you. The Cyprus authorities may also have a charge on the land for debts of the developer. We have seen, particularly since the crisis, more and more developers getting into trouble, and more cautions, effectively, what they call a memorandum, effectively a charge on the land, which affects any property which is on that land, which has been built on that land. Now, the Cyprus authorities are very unlikely to take legal action. Their attitude is, well, we wait for something to be asked of us, and when it is asked of us, we refuse to give it unless we get paid. So that is the current policy. So again, you may not know about it, but you may find that when you next try to do something, they will refuse it, because they will then check their records and say, oh, you owe us money, or in many cases you ask for permission to, if you're keeping the property and you want something done to it, to add something, or sort of a side building or whatever, they will check their records, and if there have been any breaches in planning, they will refuse until those breaches have been rectified. So the advice is, right, clean as you go. Do not leave things outstanding, because if you leave them outstanding, they will eventually come back and bite you, and it's going to be a very expensive process. You do need to take these matters into consideration. Why do you need to bother with developers? If the bank has the property has been surrendered to the bank, if you're transferring the property to the bank, it is possible that the developer will not be involved, because under the terms of your sales contract and the assignment of your sales contract to the bank, the developer only needs to be notified that your interest has been transferred to the bank. He does not need to consent to it. He only needs to consent to it when the property is being transferred out to someone else. Let's say you've sold the property, then the developer would need to consent to the transfer to the purchaser. When the bank comes to sell the property, it needs the developer will need to consent to the transfer. So although you can take the next step without involving the developer, when the developer is asked to transfer title, for example, when selling, or when the bank is selling a surrendered property, or when keeping the property, and you want the title deeds to be transferred to your name, the developer is likely to ask for money. They may also sue for money due to them, even if you have not asked them to do something. So it needs to be addressed. So why do you need to bother with the developer is that anything which is outstanding, do not let it be outstanding. Close it now. We have tried to negotiate with developers over running expenses, but they were using this to delay agreement on to drop all actions. The problem with the actions that we have in this country, if I can call it a problem, is that once you start an action and then you say, okay, I've now settled with the bank, I'd like to withdraw the action against everyone else. Automatically you withdraw the action. The opponent is entitled to any costs that they have incurred because of your action. Now, it should not be much on the one hand, because these actions were issued and stayed, but there is a potential liability there, and therefore we want to withdraw these actions by consent. This is the point where developers are finding the opportunity to say, but I'm not going to agree by consent because I'm owed running expenses. This is why we are now saying from our agreement to withdraw the action, we are excluding running expenses. And if running expenses are legitimately due to you, then it is something that we would be asking our clients to settle. But the costs, obviously, the charges which are being asked for need to be legitimate, and we're not going to hold up the drop hands agreements with developers, or with anyone else for that matter, over the running expenses, which for people, for example, who are keeping the properties, they're going to have running expenses come what may. People who have sold the property, these running expenses, anything outstanding to the developers, would have been settled upon sale because the developer would have insisted on that. It is really the clients who have surrendered, and the bank is taking over responsibility from the point, the date that the property is surrendered. But before that, it remains your responsibility. Now, some developers will do have outstanding. You may have been paying them normally, so there is nothing outstanding. Again, each case differs, but you can't ignore it, and you must not ignore it. So because of the way we're doing drop hands agreements and we're excluding running expenses, this means that they may be left with a claim for running expenses. And as I say, where the expenses are legitimate, we will need to address them. If they're not, again, we will tell developers that they are not legitimate. So this is where we stand with this. Why do you need to bother with anyone else in Cyprus other than developers? Because anyone, as I mentioned before, with let's say an owners committee who are managing the development, they can issue it against you. Enforcement of Cyprus judgments may be unstoppable even post-Brexit. So yes, Brexit will change certain things like the European Enforcement Order, which is pretty automatic, but it's only a change in procedure as opposed to the essence, which is a judgment obtained in Cyprus is enforceable in this country, and this is what you need to address. Lawyers who are owed money may not need to issue a writ against you, but they are likely to use the taxation route, which amounts to a judgment. So for them, it's even easier. If they've been involved in the case, all they need to do is to take their itemized bill to the clerk of the court and get it rubber stamped after he checks that the charges have been properly incurred. Some people, if I may add to this previous comment, some people may have instructed lawyers in this country who in turn instructed lawyers in Cyprus. They say, but you know, I've had an arrangement with the lawyer in England. I've paid the lawyer in England. Why isn't the Cypriot lawyer deducting what I've paid from there? In which case, or taking into account what arrangements I've made with the English firm. Again, the clerk of the court will say that does not involve me. I'm only here to check the itemized bill and to check whether this work has actually been done. I'm not concerned with what arrangements you've made in England. It's sad that this can happen, but it does happen. We've seen it happen. Avoiding enforcement in England means dealing with the problem at source before cost of enforcement make the position even worse. So I'm repeating pretty much the same message. How we handle such matters is privileged advice to clients only. So if you are in this situation, speak to us and we will tell you what can be done about it. So this is where we are with these costs. I will now move into the last section, which is why do I have to pay for it? A question that perhaps many of you who are existing clients have already answered, and they realize why clients who or prospective clients may have not realized that, and they continue with the idea that why can't I just ignore it? The simple answer is that someone who is owed money does not easily forget it. So at some point, even the paper debt, the book debt, is worth something to someone. even it's got even annoyance value, and it may be worth it for them to get a judgment against you, which they can then use on your to enforce on your assets in England. You don't want that to happen. A Cyprus judgment may be enforced post-Brexit. There may be no time limit on enforcing a judgment. So again, I'm saying this because some people may think, well, I'll keep ducking and diving, I can avoid them, etc., etc. Well, tracing people in this country, there are firms finding, on a no-win, no-fee basis for 25 quid to come up with your current address. So it's not difficult to find someone in the electronic age we live in. They can find you, even if they do not enforce the judgment immediately. What may happen in the following few years, having got a judgment, is that you may run into money. You may get a very good job. You may buy a property. Do you actually want to be living with this? If the debt we're talking about is 5,000–10,000 euros, and you leave it, you do not settle it now, and then you find that because of legal costs, because of interest and everything else, the 5,000 has become 20,000. It's much better to deal with it at source, so that you do not have the problem. I'm not suggesting that anybody should pay silly money or money that is not legitimately due, but I am insisting that I'm saying that it is good advice to address it now rather than leave it until later. If you are really in dire straits and you owe everyone a lot of money, you're not talking about the 5,000 or 10,000 euros owed to Cyprus, but you're talking about credit cards and everything else, and your debts are running into hundreds of thousands, then you may consider bankruptcy. But making yourself bankrupt over just the Cyprus debt is not worth it, and I would ask myself, is it worth looking over my shoulders for years over that sort of amount? It's probably worth just addressing it now. If they are at fault, why do I have to pay? These are questions that have been asked so many times. The fact of the matter is that they do not accept they are at fault. You cannot establish fault without going to trial. A lot of people tell me, well, now that they have agreed to settle, have they not admitted liability? The answer is no. They have made a commercial decision. You're not paying them, you're in bad debt, and they're saying, how much can I recover from this person? It's as simple as that. They're not admitting liability, and we cannot insist that they need to admit liability before they settle. Frankly, if they give you a good settlement, who cares? We're not going for the ideology of it. Our job is to extricate you from a bad situation. Why can I not represent myself in court? I don't need lawyers. I would be the first. I'm not a solicitor, as you know, and I would be the first to say, there should be free legal representation. Everybody's entitled to represent themselves. However, the law has become extremely complicated. Legal procedures have become extremely complicated. If you look at what it is called the White Book, even seasoned lawyers do not know all the rules. Very difficult to go through. So if you're talking about representing yourself in Cyprus, my simple advice is forget it. It's going to prove extremely difficult to do that. If anything, due to the language barrier, conducting your own defense through an interpreter and what have you is not easy, and traveling expenses and everything else, none of it is easy. But even in England, it is not advisable. The court is obliged to accommodate litigants in person. But there is still a need for knowledge of the law and knowledge of the procedures, and above all, thinking on your feet, because you will be in situations where your opponent will say something and you will not even understand what they're referring to. The barrister of your opponent will know they have their own language, which the judge will understand, and you would be the person who is the outsider, and you would be constantly playing catch up. This is not to deter you from representing yourself, but this is again advice from anyone who has experienced court proceedings. They are intimidating, they're not very easy. If there are proceedings in this country, why can I not have free legal representation? Now, in practical terms, legal aid is not available to defend claims of this nature. Even when we had a fully fledged legal aid system, it was mainly concentrated on criminal cases, not on this sort of case. And as you would have heard, legal aid is constantly being curtailed. So the problem that we have with generally the system of justice is that whereas things like health and security are on top of the agenda, and when you say to a taxpayer, we have to increase the taxes because the National Health Service is costing us whatever it needs to be funded, or the police is costing us whatever it needs to be funded, voters consider that to be a universal right, and it's money well spent. Access to justice, unfortunately, has not made the mark. So voters will agree that yes, some money should be spent to represent people who are we've got criminal charges against them, but to a very limited extent. But the attitude of society generally is that out of sight, out of your mind. If somebody is guilty, throw them in prison and throw away the key. And if somebody is found guilty because they've had very bad representation, then well, they were found guilty. That's what matters. The fact that they may have been innocent and with better representation, they would have done much better in court, is again irrelevant to people. And what is happening is because legal aid rates are so low, a lot of barristers are now not doing this sort of work. A lot of solicitors are not doing this sort of work. So generally, access to justice is not considered as a universal right. You as taxpayers have not supported that idea strongly enough, and it's simply not there. So this is perhaps a deficiency you may need to make more noise about for it to change in future. I'm all for it. I believe that if you're going to have a justice system, this is the only fair way of doing it. You do not want a justice system that only works for the rich. But here we are. So who pays to sort all this out? I don't think I need to answer that, because the inevitable conclusion is that there is a lot of sorting out to do and someone has to pay for it. Having to pay for unexpected costs is not pleasant for anyone. So again, if you think in terms of health and policing, can you imagine if we did not have those free as a universal right, and you had to pay for protection because there's criminal activity in your area, so you have to get your own private guards, or you have to pay for an operation. It could ruin you. If you're faced with a legal bill, that can also ruin you. It is horrendous, without a doubt. The fact of the matter is that in just the same way that if there was no free National Health Service and no free policing. You would need to come up with the money, and you wouldn't be able to say, well, I'm sorry, but I haven't budgeted for it. It's the same with legal representation, I am afraid. The best you can do in the circumstances is to find someone who's not going to present you with a runaway bill. A lot of solicitors work on a taximeter basis, pay me before I even open my mouth, and sort of attitude. So it's a matter, as matters stand, of doing the best you can in the circumstances. So our approach means very low cost and reasonable resolution to your matter. We believe that compared with all other firms that have been involved in this, we have managed to get this absolutely right. We can show you hundreds of testimonials who will say this, speak to any of the customers who've been through the process, and this we believe is the best possible compromise. Most of these clients are already resigned to the fact that they need to pay to extricate themselves from this mess, and are grateful for our unique approach. I will tell you more about our unique approach in a minute. We believe that we are the next best thing to a free access to justice scheme. So thus I'm stuck with having to pay lawyers. I'm afraid so, but most lawyers do not deserve their reputation. Again, let us remind ourselves why solicitors do have a bad reputation. And the first item on the list must be that because you have to pay their bill. Believe me, in countries where people have to pay for medical health, they too, doctors also have a very bad reputation. You may remember way back when people were talking about white envelopes to Greek doctors to get anything done, simply because their national health service system was so badly paid. We don't have this in this country, but if you are presented with a bill, particularly an unexpected bill, you do not exactly consider the person giving you the bill. You do not see them in a very good light. But there are also more fundamental reasons. Legal representation in this country is extremely expensive, particularly because of the standards that we have to keep. We need to be insured. Insurance premiums are extremely high, and one needs to be very careful about any claims on their professional indemnity insurance. Otherwise, premiums go up, and it may make it impossible to continue to operate if they become prohibitive. We also have many regulatory standards to maintain. All of this, which is obviously a cost that somehow needs to be paid. If for example someone decides to write in and complain, I cannot charge for my time because this is what the regulations say. Now, where there are genuine complaints, no problem, we should not be charging, I agree entirely. But where the complaint is vexatious, it does mean that this cost has to be taken into account in the overall costs of the operation. Who pays for it at the end of the day? Obviously, the Mr. Public, who is expected to pay every bill at the end of the day. Also, there are no the more intuitive ways to cover costs do not always work. I mean, we've tried this, as you know, with conditional fee agreements and what have you, and a lot of people find the opportunity not to pay at all, and there is then an add-on cost of chasing after people, and then when you catch people, you say, but you've got to pay me, it's only fair. We also have mortgages to pay and to put food on the table. How do you expect this to run for nothing? They also get very upset. So again, they will blame the solicitor when in actual fact it's simply acting in bad faith in the first place, with no intention to pay, get something for nothing. Because litigation is safer for solicitors than alternative dispute resolution. I say this because a lot of firms will find litigation is the only tool they've got in the toolbox. Litigation is easy. I put this in inverted commas in that you say, okay, you've got a dispute, right? Let's take it to court and let's see what the judge says. Whatever the judge says, I as the solicitor can put my hands up and say, well, it wasn't my decision, it was the judge's decision. If I'm doing alternative dispute resolution, it means that I'm actually involved in resolving the matter, and it's much easier to be blamed for the wrong maneuver or agreeing to settle for whatever you've agreed to settle for and so on. Litigation is much easier because a judge decides and you can just pass on the problem to the judge. This may be unfair to say that all firms tend towards litigation, but you will find, for example, in our case, we have moved in litigation, and the average cost of the average shareable cost for our litigation expenditure in terms of court proceedings, barristers, and what have you, was around £1,000 per client account. Compare that with some bills that we've seen running into tens of thousands of pounds, and you will understand what we have been doing right. And because not all firms know how to cut through the chase. Again, I've seen bills for someone to go through the folders and documents of folders as a reading fee. And you say, oh, hold on, I mean, most of these cases, they've got common denominators. Why do I need to go through all the month, through each and every email that has been exchanged 15 years ago to find out what happened? We know what happened. What is important is what is the solution. Start from the solution and see what actually needs to be done. Now, this is what an expert firm would do, a firm that knows what they're doing, whereas a firm that follows procedure will say, well, how can I advise the client without reading each and every document and highlighting various sentences and what have you? And my answer as a non-solicitor is because you don't need to. You would only need to do that if the matter is going to court, and it's very important during cross-examination to say to somebody, but you wrote this on such a date. We're not there. All we're doing is going to the bank and say, look, you've got a bad debt. This is a headache for you. I've got a solution to solve it. I am the painkiller for you. Why do I need to go through reams of paper to do this? So you can see the different approach involved. Our approach is that we follow a straight run, as I've explained previously, and we also do a lot of strategic planning. What I mean by that is that because we group clients together, it means that we can have a strategic plan of how to solve all the cases that fall into this particular category. I've given you the example of running expenses, for example, where I'm saying, okay, we can do something about it. And I'm saying this having pretty much this in mind. If there are a lot of clients with the same developer facing the same problem, why not come up with a plan that will benefit all of them, and therefore they can share the cost? And again, the approach is always a straight run. What is the problem? How do I solve it? Let me find the solution, and once I find the solution, then I'll work out what I need in order to process that solution, not vice versa, not going through reams of paper sort of looking for things in the dark, just in case inspiration hits me. You've got to know what you're doing. We followed an approach which was to secure and protect clients. In other words, we filed actions in this country in order to secure their position, in order to state their claims so they do not run out of time, so that the opponent does not jump the gun and sue first. It's important, particularly when you're dealing with litigation, that you preempt a situation, and we protected clients by claiming English jurisdiction, and that scheme worked extremely well. We said from the beginning that we operate on a strength in numbers basis. What that meant was that by becoming the largest group in the country dealing with these matters, not only do we have a much stronger negotiating position, but also costs are being shared by many more people. Now, when I first started in 2012, I did approach all of the other firms, both in England and in Cyprus, representing clients, and I said, why don't we share resources? Each one has their own clients. We do not have to argue or compete with each other on clients. Everybody has got their own clients, but we can share resources. We can have the same barristers, for example. We can share the same advice. We can even negotiate on behalf of all of us from a much stronger position. This proposal was not taken up. There was no cooperation, and because of that, it made us, in actual fact, this helped us to become the largest, because a lot of victims realized that this was the way to do it, and they started coming to us. And by coming to us, the costs themselves started coming down. We offered fee options, including no win, no fee, and initially clients also benefited from installments. So again, very flexible on that. And we're also a campaigning firm. Since I started this, as most of you know, I have been campaigning to get resolutions. And it is this campaigning that actually put pressure on the opponents, made the issue topical enough for them to address it. So this was the background that meant that I could, if I wanted to see a minister in Cyprus, I could arrange to do this and meet them and explain what the problem was, and thus put pressure on the banks and the developers to realize that the matter was not going to go away. So this was our approach on Cyprus, and it's been extremely successful. The model is as close as you can get to a fair way to access to justice. May I thank you for joining us this morning. If you are existing clients, thank you for your support all these years. If you are prospective clients, we look forward to welcoming you in due course. Thank you.